The Zimbabwean government on Monday appealed against a High Court ruling that extended the Chief Justice's tenure by 5 years was illegal in a case that has threatened a standoff between President Emmerson Mnangagwa and the court. Lawyers had challenged a constitutional amendment that raised the retirement age of constitutional and Supreme Court judges to 75 from 70, which allowed Mnangagwa to extend Chief Justice Luke Malaba's term of office. This has renewed concerns over judiciary independence and democratic backsliding during the coronavirus pandemic. To discuss this, I'm joined by Dr. Thompson Chengeta, a human rights law expert, and we are expecting Professor Lovemore Maduku to join the conversation. Doctor, very good morning. Thank you so much for speaking to us. It's all happening with the judiciary in Zimbabwe at the moment.
Thank you very much for having me.
So what are the major concerns around what has transpired in Zimbabwe regarding the judiciary, in particular, obviously, Justice Luke Malaba's failed extension to his tenure as Chief Justice?
I think the first thing as regards the judiciary in Zimbabwe, they have always been claims that there is judicial capture, there is no judicial independence in the country. And one of the things which many people or commentators or stakeholders, as it were, make clear, the blame usually is squarely placed on the executive for its interference, and that's the mode of interference is usually thought to be through use of force and intimidation. But with the Malaba case, I think one troubling aspect of judicial independence is also laid bare. And this is the idea that as far as the lack of judicial independence in Zimbabwe, sometimes, especially in the case of Malaba, it is also on account of the willing judges, the judges who will be willing to be, supporting the dictatorial tendencies of the executive. And in this circumstance, there was no reason whatsoever on the part of Justice Malaba, whose term came to an end on the 15th of May 2021, for him to have gone the route which he chose in this particular circumstance. So it gives this idea that sometimes, in as much as the executive is responsible for threatening judicial independence in Zimbabwe, there are also, to some extent, some willing participants. And in this case, and unfortunately so, we have a whole Chief Justice, the leader of the judiciary itself, being a willing participant in as far as compromising judicial independence is concerned.
Now, Dr. Chengeta, what obviously paved way for this scenario was President Emmerson Mnangagwa's constitutional amendments, certainly that his party pushed through, that concentrated power in the hands of the president. And this is something that has recently happened. Take us through what those amendments to the Constitution were.
Thank you very much. Basically, actually, there were two main amendments regarding the judiciary. The first one being Amendment number 1 to the Constitution. And this Amendment number 1 was essentially giving the president the power to appoint judges of the higher courts without necessarily having to go through the process that was existing in the Constitution, that is, issues of public interviews, and then afterwards, the president, after conclusion of public interviews, now going ahead to appoint an individual who would have been recommended to him by the body that is responsible for those interviews. In that constitutional amendment number 1, what was essentially happening is that the government of Zimbabwe sought to remove this process, which allows transparency in Zimbabwe, to fetter all those powers in the hands of the president. The problem with that particular amendment was essentially the idea that the bill, when it was presented in the Parliament of Zimbabwe, actually expired when the Parliament of Zimbabwe lapsed in sometime in 2018. Yet the same bill, which was now non-existent at some time now in 2021, was again presented, or they proceeded as if it was still a legitimate, it was still a valid bill, which was no longer valid, and continued to pass it. In essence, they were passing that something that no longer existed. That is the first issue, which means procedurally, the executive sought to extend the powers of the president with a bill that no longer exists. That is an amendment number 1. Amendment number 2, which is recently referred, others may want even to call it the Malaba amendment, is the one in which the president sought now to increase, particularly, the age of the retirement age of the judges from the age of 70 to 75. Now, the problem with that amendment was that in terms of the constitution of Zimbabwe, when you want to do that, you are supposed to go certain processes in the constitution, because increasing, that is the argument, increasing the age, retirement of judges is tantamount to increasing their term limit in office. And in terms of our constitution, it makes it clear that when you do that, you do not necessarily only need the 2/3 majority in parliament, but you would also need to take that particular amendment or bill to the public for a public referendum. This was not done. In fact, the government has been arguing to say that, an increase of retirement age is not necessarily an increase of term limit, which of course many legal experts disagree. The problem though, Hugo, while I must want to go into the technicalities of these two amendments and what it means for judicial independence, I think what is more important, above and beyond these issues of technicalities, is what that actually means for the rule of law in Zimbabwe, for human rights and democracy. In this particular instance, we are having a situation of where a government, we are having a situation where the executive is changing the law, and not an ordinary piece of legislation, the constitution of a country, which is the soul of the nation, to fit the needs of a friend. I call him a friend because in the circumstances of coming to the background of the case, you see that Malaba, at least respectfully, was implicated of having been biased, for example, in the election challenge that happened in 2018, where many felt that perhaps he did not particularly handle that case properly, which was in favor of President Mnangagwa. Now, when you have the president who was implicated of having been favored by the judiciary, particularly by Justice Malaba, now changing a whole constitution to extend the term limit of a particular individual, a whole constitution to fit just one individual. This is a sad day for rule of law. This is a sad day for human rights. And when I talking about this issue beyond technicalities, these are some of the ideas that come into mind, because questions which you hear, Hugo, you hear people asking, what are the prospects at appeal? Because you understand that, after the High Court judgment was issued on the 15th of May, just 2 days later, on the 17th of May, the government of Zimbabwe filed an appeal to the Supreme Court. The question which others ask is, what are the prospects of the government succeeding in this? And I have been emphasizing to say.
Maybe I could ask you, Dr. Chengeta, what is the basis of that appeal? Obviously, from what you've outlined, it's pretty clear that there is a breaking of the law. There is a need to amend the Constitution. So what would be the basis of that appeal by government, certainly launched by Ziambi, who is the Justice Minister?
Thank you very much, Hugo. The question which you asked, as I was indicating, that many do ask to say, what is the basis of the appeal? What is the potential successes or potential success of that particular appeal? They've outlined, I think, about 8 grounds of appeal, which I do not want to perhaps go into detail with, because most of them are too technical and, in my mind, at least, are baseless. Picking just some technical things within the High Court judgment. What you need to note, though, in explaining their basis of appeal, is to say that the High Court judgment of 15 May 2021, which was given by Justice Joe, does not necessarily go into the constitutionality or constitutional validity of amendment number 2. Rather, the judge appeared to have proceeded on the grounds as if that even if that amendment was constitutionally valid, in terms of the Constitution, the incumbents, including Chief Justice Malaba, or the former Chief Justice Malaba cannot benefit from that particular amendment in as far as the increase of age of retirement is concerned. Now, what is fundamental, at least as I was trying to emphasize, is to say that even after the 21st of May, there has been a file or an appeal to the not an appeal, an application to the Constitutional Court, now challenging the constitutional validity of Amendment number 1 and Amendment number 2. And what I was saying that is fundamental for the Zimbabweans or the general public to understand in this regard is to say, look, regardless of the legal technicalities which people may want to say, or the ground which you are here, which you are saying, what does this mean? I don't even understand this. There are clear things which you need to remember, and there are just 4, which I would want even to highlight. The number 1 is that when it comes to the term limit, of how much time a judge can spend in office, 93% of Zimbabweans, when they passed the Constitution of Zimbabwe in 2013, made it clear that it has to be 70 years. Not only that, but they also made it clear that if you wanted to change that position, if you wanted to amend that position, there was a certain process which you needed to follow, particularly having a public referendum. This was not done. Number 2 is also the aspect that even fellow judges to Justice Malaba, or former Chief Justice Malaba, do not agree with him. And here I'm regarding the judges in the High Court who ruled to say that you are not supposed to continue, your term has lapsed. Number 3 is also to note that the civil society, also tasked with advocates of human rights and human rights protection in Zimbabwe, do not agree with Justice Malaba. You would understand that the application was in fact filed by the NGO Forum, which is a coalition of civil society tasked to advocate for human rights in Zimbabwe. They don't agree with him. Number 4, and most fundamentally, is to say that the constitutional amendment that I have just referred to, which was filed on the 21st of May, it has been filed by the Law Society of Zimbabwe. The Law Society of Zimbabwe being that organization that first regulate the conduct of legal practitioners, or those who are registered as legal practitioners, under which also judges fall in that category. They are also interested in the issue of independence of judiciary and protection of human rights in Zimbabwe. Now, the fundamental thing here to note, in short, Hugo, is to say, if the stakeholders to human rights, whom I have just mentioned, are clearly opposed and clearly articulating the position of the law to say, you were not supposed to do this, including the Law Society of Zimbabwe, to which Malaba actually needs to also show, because it's also regulated under the same organization. He's saying, you are wrong, you are not supposed to do that. The appeal, therefore, which you may give, regardless of what judges in the appeal may say, which I think are also conflicted because they are cited in this case, whatever they are going to decide, will be, at least in my view, something which is a sad day of Zimbabwe. Because they are actually supposed, at this point, if we're talking about democracy, to have just withdrawn that appeal altogether.
Dr. Changeta, thank you kindly for your time this morning. That was Dr. Thompson Chengeta, a human rights law expert, speaking to us from Southampton in the UK.